Okay, so I'm going to go ahead and get started and welcome everyone to our National Family Caregiver webinar series. So we are hosting this webinar series during the month of November for National Family Caregiver Month, and we are excited to have you with us as we discuss topics that are important to dementia family caregivers and to caregivers in general, actually. Tonight we have Attorney Alexier Barbour. Next Tuesday, we'll have Leslie Poole from the Rosalind Carter Institute, who will talk to us about emergency preparedness for caregivers. And then finally, the last Tuesday of the month, we will have a death doula, Darnell Lamont Walker, where we'll discuss grief and tools for coping with grief for caregivers. So we have some interesting topics this month, and I am happy to have you here. Make sure you register for the other events that we have throughout the month. And so I'm actually going to go ahead and get started with Alexier Barbour. So I actually have a wonderful bio here for Miss Barbour, but I'm going to ask you to tell us a little bit about yourself and why you believe this topic of estate planning is important to our community.
Thank you so much, Veronica. I really appreciate the opportunity to speak to your Dementia Care Warriors family and our community regarding estate planning and caregiving for those that are serving and honored to serve in the role as caregivers. I am a caregiver myself, and so I am a caregiver to my mother who has dementia. She is in the mild to moderate stages. I'd say at this point more moderate, and I've been caring for her for the last 9 years. And it's an honor and privilege to do so because I know if the situation was reversed, she'd absolutely do it for me. I am an estate planning and probate attorney. I have a few other practice areas, but my primary practice areas are estate planning and probate. This is not the practice area that I planned on working in when I went to law school. I went to undergrad at Grambling State University, so I'm an HBCU grad, and law school at LSU. LSU in Louisiana law is distinctive because the legal system is similar to that overseas. And so I planned on going into more international corporate law. There are two exams that you take to become an attorney. There's an ethics exam and a bar exam. I took the ethics exam on August 15th. I took the bar exam the last weekend of July of 2015, the ethics exam August 15th, and my sister passed away unexpectedly on August 16th. And her estate was the first estate that I probated. And I recognized that there was a need for estate planning, particularly in our community. There are so many of us that don't understand the need or the importance of estate planning. And I felt led and called to do this work. And so totally shifted my focus. My family, we had started noticing that my mom was having some memory issues in the spring before I graduated from law school, but my siblings and I were waiting until I graduated to decide what to do. And so I knew after my sister passed away unexpectedly that my mom could not go back to East Texas and continue on by herself. And so she's been with me ever since. And so this is very personal for me. I'm honored to do this work. My primary life consists of taking care of my mom and managing a law practice. I'm very active in the community and do a lot of work with the Dallas Bar Association, the State Bar of Texas. I am a charter member of Alpha Kappa Alpha, Alpha Alpha Omicron Omega chapter, which is in the Sunnyvale, Forney area. And so I do a lot of community service. I spend time with my family and take care of my mom and try to have this work-life balance that all of us as caregivers know is incredibly difficult, but we try to get it done. So that's my life and that's me in a nutshell.
Wonderful. Thank you. Thank you for sharing. I kind of want to start with just some basic information for someone who might not be familiar with estate planning. So, my first question is, what exactly is estate planning?
So, and I took some notes because I am just a type A personality. So I'm working on multiple screens. So if you guys see me looking over, don't think that, I'm just exhausted and, oh, she's not focused. I'm looking at my notes. But essentially, estate planning is the process of organizing and structuring your life and your estate, which are the assets that you own, the debts that you hold, any property, if you were to cut the roof off of your house or your apartment and shake all of the things, everything that falls out, all of those things are part of your estate, your bank accounts, your retirement accounts. So it's organizing and structuring those assets in a way to identify what your assets are, allow your individual that you trust, which depending on which document you draft would be an executor or trustee or this agent who is going to be responsible for managing those assets and distributing those assets after you pass away. So estate planning is essentially getting all of your affairs identified, classified, and then put in some type of document so that at your passing, your loved ones can know what assets you own, what your debts or liabilities are, and to whom you want to leave those assets to. So if you were to have, and it's very easy for people to assume, hey, I don't have an estate. I have an apartment, I have a bank account, I have a car, I don't own a home, I don't have kids, but you still have an estate. All of those things that would fall out of that apartment are a part of your estate. The funds in your bank account, if you do not figure out the process to name a paid on death beneficiary for that bank account, can be a part of your probate estate. And also, you don't know the method and the manner of your passing. So if you were to pass away, and there was some type of medical malpractice, or if you were to pass away with some type of accident and there was a claim or a lawsuit, and there's funds that you are entitled to or your estate is entitled to, who gets that money? And so estate planning allows you to identify assets that you currently own or that you may be entitled to at your death and to whom you'd want those distributed to.
Thank you. I know something you mentioned was the beneficiary on your bank account. And that's
Yeah.
something I want to stress for us as caregivers to make sure that our loved ones and ourselves as caregivers have that completed or go
Yeah.
to the bank and make sure that we have that because it's an important thing that I've dealt with when it
Yeah.
was, you know.
And here's the thing, there's a common misconception that if I'm on someone's account as a joint account holder, then it doesn't matter, but it does. And I'll give you this illustration. So let's say, because I am a solo practitioner, I'm the only attorney in my law practice. So let's say, because Veronica and I have gotten to know each other over the last year or so, and let's say I put Veronica on my account as a joint account holder for my business account so that if something happened to me, I have a succession plan in place, and Veronica knows that these are my current clients and actually have this plan in place. We're required to as attorneys. I have another attorney. But let's say, for illustration purposes, that Veronica is on that account with me. Just because she's a joint account holder does not mean that she's entitled to those funds at my death. And so you have to have someone listed as the beneficiary on your bank account, even if you have someone as a joint account holder. By Texas law, at your passing, once the bank is aware of someone passing away, they're supposed to freeze that account. And so you are going to be limited in accessing those funds. Now, if you have someone listed as a paid on death beneficiary, all you have to do is follow the bank's internal procedures to get access to those funds at the passing of the account holder. That typically requires you to provide them with a death certificate and then fill out whatever their internal forms are. And then from that point, they will go ahead and cut you a check for the balance in the account or transfer them to your account. But if you don't have someone listed as a paid on death beneficiary, then those funds in that account become part of your probate estate, and you have to go through a probate process with the court in order to get access to those funds. So a lot of times I'll get phone calls from individuals whose loved ones have passed away. They didn't realize that their loved one didn't have anyone listed on that account. And now they're having to hire an attorney to get access to those funds. And they need those funds to, pay the mortgage or to um, pay for funeral expenses or what have you. And so this is homework for everyone. I encourage you tomorrow to contact your financial institutions, your life insurance, your retirement accounts, and make sure that you have a living beneficiary listed on those accounts. Because if you don't, instead of those accounts going based on your contractual language with that entity, whether it's Chase Bank or State Farm for your life insurance or Fidelity for your retirement accounts, now those assets will have to go through a probate process where if you have a will and you've identified who receives those assets in your will, those individuals will receive those assets. But if you pass away without a will, your assets are distributed in accordance with Texas law. Currently, Texas intestacy law is based on per stirpes. It sounds like a ridiculous legal term, but it goes based on the hierarchy of your loved ones. So if you're single, you aren't married, you don't have any children, your estate is going to go 50% to your mother, 50% to your father. If one of your parents is deceased and you have siblings, those siblings will stand in their place, so on and so forth. And it can become incredibly complicated, and it may not be the way you want your estate to be distributed. This family has given me permission to tell this story. Anytime I have interviews or presentations, I share the story of a Tatiana Jefferson who is in Fort Worth. She was looking after her nephew. She was cooking late one night. Her neighbor saw that her door was open and called the police to do a welfare check. The police came in, they thought it was a burglar. They shot and killed her. Her father, that she had never had a relationship with, went to Tarrant County Probate Court and opened a probate matter because he anticipated that there would be a settlement from the city of Fort Worth for her death. Like I was talking about, these funds that you're entitled to from your estate. She didn't have a lot at the time of her passing, but because of the manner of her passing, there was going to be a settlement. He anticipated that, opened probate because he knew he would be entitled as her father, because she was not married, she did not have children. He would be entitled to 50% of her estate. And her sisters, with tears streaming down their face, shared this story, and they implored everyone listening to make sure that they went through the probate process, because they know had their sister done so, she would have drafted a will, leaving the assets to her loved ones that she had a relationship with. So even though she wasn't a caregiver, it still applies to everyone. You have to create an estate plan because you don't know what the future holds.
Absolutely. Thank you. That's an interesting story. And it kind of leads me into my next question, which is about the misconceptions people have about estate planning, especially in the context of dementia care.
So I will say some of the misconceptions about estate planning is that one, people think that they have time, particularly with caregivers. We will make the assumption that we have a lot of different avenues available to us just by the nature of the way life is set up now. You know, at the beginning of our starting this webinar, the two of us were talking about the technology that we have in regards to being caregivers. So we have the medical alert bracelets, we have the cameras in our home, we have all of these systems in place. And so we assume that we have more time. But the reality is, once you get that diagnosis, your clock is ticking. And really, even before, once you start noticing that your loved ones are having issues with their memory, there's a ticking clock regarding your ability to draft these documents. In the state of Texas, and really, as far as I'm aware of, in every state, you have to have capacity in order to draft any type of legal documents. And so you're saying, well, what is capacity, Alexier? So I'm going to actually read to you how the law stands and kind of give you some examples. So for estate planning to be valid, the individual must have testamentary capacity or contractual capacity. So depending on which document they're drafting, whether it's a will or a trust or power of attorneys, and we'll talk about that a little bit more in our conversation. But in Texas, generally, testamentary capacity requires four things. One, that the person understand the nature of the act. They understand that they're making a will, or they're drafting a power of attorney, or that they're drafting a healthcare proxy, or they're drafting an advance directive or a living will. So one, they need to know what document they're drafting. Two, they need to understand the nature and extent of their property. So they need to know what they own. They need to be able to identify to me as the attorney that they own a home, land, that they have two or three vehicles in their name, that they have some artwork, that they have a pretty valuable vinyl collection, whatever they own, the extent and the nature of their property. They need to be able to recognize the natural objects of their bounty. And I know you're like, okay, what does that mean? They need to understand who you are. They need to understand who their loved ones are, identifying their family members and who their other potential beneficiaries are. So if they're planning on leaving their estate to all of their children, they need to be able to name all of their children. If they're leaving their estate to their nieces and nephews, they need to be able to identify who those people are by name. They also need to be able to identify any other potential beneficiaries. So if they're leaving their assets to a charity, I need to be able to know what charity it is. They can't just say, well, I want to leave my estate to breast cancer. I
Mhm.
need to be able to know what the particular charities are and who the beneficiaries are. And lastly, I need them to be able to articulate that they understand how the will or the document disposes of their property or the nature and effect of the document. So if we're drafting a medical power of attorney is where an individual will name an agent who will make healthcare decisions for them when they are unable to do so. And here's the key, that person needs to be able to make decisions in accordance with the wishes of the individual who they're making decisions for. And so they need to be able to honor the wishes of that person. It needs to be someone that they know and they trust. So in a situation like that, in the consultation, I need them to be able to identify to me that they want to draft a power of attorney, that they understand that this person will be able to make medical decisions once they're unable to do so, that they're identifying who that person is, and preferably an alternate, because in the event that that person becomes unable or unwilling to serve, someone else can stand in their place behind them. And they need to understand the effect of the document, that this document in the future will allow doctors to be able to listen to this individual, and this person will be able to give direction in regards to the health care of that person. If they are unable to do that, they do not have contractual capacity or testamentary capacity. And by law and ethically and morally, I'm unable to draft documents for them. And so, as a caregiver, I already know what the next thing
Question.
is. You're thinking, okay, well, hey, you know, we're at the early stages, and my dad's memory comes and goes, and he's better in the morning, and sometimes he may not be feeling well, or if he has the flu, or he has the flu if he has the flu or a cold, then I notice that cognitively he's not there, but when he's at his best, he's able to recall everything. So those are lucid intervals, and caregivers, we absolutely understand what that means, right? And as an attorney, it's not my job to determine capacity, so to speak. It's my job to ask those four questions, identify those four areas that we talked about. And if during our conversations, I can tell that that person doesn't have a full understanding, I have to stop. Now, if you know that your loved one is typically does better in the mornings, schedule your consultation with me first thing in the morning. We can talk. I can get a full understanding from them. If you know that they're having these lucid intervals, if you know that medication plays a part into that, factor all of that in when you're doing the consultation. But one of the biggest misconceptions is that I have time. And as caregivers, we're putting out fires, right? That's what we do. We have a list of things to do. We have these tasks throughout the day, and we have more tasks than we do time. And so we're constantly thinking about all the things that we have to do. I'll share with you part of my day. So I'm in physical therapy for my back, went to physical therapy, and then I went all over this land and country looking for my mom's Exelon patch, which is a patch that she wears for her memory, and it's been on back order in a lot of pharmacies. So I went to Barney. I was told at Walgreens it was going to be ready in 90 minutes. I got out there, they didn't have it. I just ended up going to a couple of different pharmacies. It was very stressful, but it was very important to get this done. So I'm putting out fires all day long. You guys understand that. You do the same. And we think that we have time, but this is one of those things that unfortunately we don't have the luxury for time. You have to make this a priority. And as soon as you know that your loved ones are already starting to have that diminished capacity, you have to get in front of an attorney right then to draft these documents.
One thing I want to say, there's a Q&A option on here. So if you're thinking of questions as we're having this conversation, you can drop them in the Q&A, and then at the end we'll go back and look at those questions and try to answer them. So if you have questions as we're talking, feel free to drop them in the Q&A and we'll get to them at the end. I actually have a sub question
All
from
right.
what you just asked about capacity.
All right.
So if you were not proactive and you did not do all of these things when your loved one had the capacity to do them, but they still need to be done. What is your option at that point?
So first off, let's just say that if that happens, because it happens more often than not, we won't realize that our loved ones are having issues with their memory until it's sometimes too late. And I say it's too late because there are some resources for which the door has closed, but you still have viable options. And so if you find yourself in the position to where your loved ones have this diagnosis and they went from having capacity and everything being good till 2 or 3 weeks later, they went down really fast. Your alternative at that point is to seek formal guardianship with the courts. And so, depending on the county in which you live, if you live in a larger county like Dallas, Harris, Tarrant, we have statutory probate courts. In the smaller counties, it's probably going to be your county court at law. You will need to hire an attorney to draft an application for guardianship. There can be a temporary guardianship that's established. That guardianship expires after 60 days in the state of Texas and it can be renewed once. But then you are named your permanent guardian. And this is a continual process that you will have with the attorney because you have to go before the court every year to become essentially recertified. The court is going to look at how the individual is doing. The individual is then labeled in the legal system as a ward, and they lose certain rights because cognitively they are no longer able to do certain things legally. So they're no longer able to vote typically. They're no longer able to have a firearms license or to have firearms. And there are certain things, depending on diagnoses and the level of diminished capacity, there are certain rights and privileges that are removed from that individual. There are two types of guardianship. There's guardian of the person and guardian of the estate. And the court will typically name the guardian as the same person unless you are not able to qualify for one for whatever reason. I have seen situations where because the individual that applied for guardian may have a criminal history or they may have had a bankruptcy or different things financially, they are named as the guardian of the person. And then the court will name an entity as the guardian of the estate, such as senior source or a bank. And it really depends on the amount of assets that the guardian has. And then there may be a bond that is required to ensure that if the individual that's serving as guardian somehow fails to act within the best interest of that ward, then there are funds that can be replenished to the ward and their assets. So, guardian of the person, you are going to be in charge of where that person lives, eats, sleeps, their medical care. It is the equivalency of the medical power of attorney. Guardian of the estate, you are going to be in charge of their assets. So you would be able to pay their rent or mortgage. You would be able to pay their premiums for their insurance, file their income taxes, and all of the things that you would be able to do with the statutory durable power of attorney. However, the thing about this is the guardianship process is a continual process with the court and it is expensive, which is why I said that time is of the essence and you don't have the luxury of time once you notice that your loved ones are starting to have issues with their memory. You really need to go ahead and get those power of attorneys drafted because those documents can save you thousands of dollars in those guardianship court fees because obtaining a guardianship over someone can cost easily five to $10,000 easily. Okay. And the reality is, a guardianship does not ensure that you're going to be able to do everything that you want to do because you have to recognize that your loved one is still a human. They still have the ability to protest. If you are guardian of the person, you can decide where they live and who their doctors are. You can decide their medication, but barring some type of mental health or psychological breakdown, you're somewhat limited in what you can do in regards to forcing them to take medication or forcing them to do certain things. So I just want to say that even if you go through the guardianship process, most attorneys that practice in this area are going to tell you that it's not foolproof because that individual, even though they have a lot of rights removed from them, they're still human and they can still refuse and they can essentially make things difficult. And while you may go to the court and get these orders, it's going to take a lot of patience, a lot of care, and a lot of grace in order to see the guardianship process um, go successfully. So,
Okay. So we just mentioned statutory power of attorney. I know there's durable power of attorney, medical power of attorney. Can you talk a little bit about power of attorney and like what the difference kind of
sure.
surface level?
So, the two main power of attorneys here in the state of Texas, and really any state, you're going to have a statutory durable power of attorney, and then you're going to have a medical power of attorney. And some states will call them healthcare proxies or healthcare agents. They'll say there are a lot of different names, and I'm saying that because we don't know where the individuals are that are watching. And so, depending on your state, it may be called a durable power of attorney or a healthcare power of attorney. But with the medical power of attorney, you are designating someone that you trust to make medical decisions for you when you're unable to do so in accordance with your wishes. So, if you are an individual who, because there are some religions that don't accept blood products or blood transfusions, you need to make sure that you're appointing someone who is going to adhere to your values and they know you well, and they're not going to do what they would want for you. They're going to do what you have advised them of while you still have that capacity. There are certain things that a medical power of attorney cannot consent to. They cannot consent to abortions. They cannot consent to psychotherapy or like electric shock therapy. They cannot have someone involuntarily admitted to a mental health facility. So, for those that are here in the Dallas Metroplex, they can't just have you transported to the Terrell Mental Health Hospital. There's a process that they have to go through. So, there are certain things that you cannot do as the medical agent. You can decide if you want that document to go into effect immediately, which is something that I recommend if you know that your loved one is having issues with their memory and you know that it is trending fast and going down fast. Or you can wait until a doctor certifies in writing that that person lacks capacity, and then it will become a validly executed or a validly enforced document. Then there's the statutory durable power of attorney. This is the power of attorney that will allow someone that you trust to make financial decisions for you. That is a wide array of things, including real estate. So they could sell your home, or if you decide to move to like an assisted living facility, they could make your home an Airbnb. They can sell your vehicles. They can renew your vehicle registration, file your taxes. They could file a claim for hail from your roof with State Farm. They can do all of the things that you do now to handle your business. In the state of Texas, statutorily, there are a list of things that are specifically listed in a power of attorney. And I really encourage you to, because I saw in the Q&A already, I kind of peeked. I saw that there was a question about, do you have to hire an attorney for the power of attorneys, or can you do them on your own? Yes, you can do them on your own. There are some that you can find online. I encourage you, if you look for them online, to look for them from reputable sources that are usually a governmental entity, because you want to make sure that they have the required language in them to make them validly executed in the state of Texas, and that they have all of the tasks that you're going to need to accomplish. So, there are some power of attorneys that I've seen via like those legal Zooms or the prepaid legal, or for those that work for corporations, sometimes your employer will offer you free legal services. But the problem with that is that often those individuals, because they work for an organization, they're only required to be licensed in a state. And so I've seen a lot of people find these power of attorneys online. or they'll go through like a legal Zoom and that person isn't licensed in Texas and the power of attorney doesn't have all of the language in it that it needs to have. My power of attorney has specific language that will allow you to create a trust, and it would not be considered um, self-serving. I have language in there that will allow the power of attorney to give away assets, and it's not considered a violation of a breach of trust or acting in bad faith if you need to sell down assets to qualify for different governmental benefits. And so it's one of those things where it's better to go through an attorney to make sure you do it correctly. But if you just can't afford an attorney, you have the option of trying to get free or reduced legal care through legal clinics all over the Dallas area, through Legal Aid of Northwest Texas. And you can go to legalaid.org, and Legal Aid is, I believe, operating in almost every state and regions across the country. And so you can likely get some documents prepared for you that way. But if all else fails, look for documents at a reputable source. An example of that is I believe there are some power of attorneys documents on the Texas Department of Health and Human Services website. At least there were a few years ago. And so that's a governmental website, which means that whoever drafted those documents for the Department of Health and Human Services was likely a licensed attorney in the state of Texas, and they likely copied the language directly from the Texas Estate Code, so you know it's going to be right. But this is one of those things where you don't want to be cheap on it because the effect of going the cheaper route can be detrimental for you when you're talking about a caregiver situation because that person may not have capacity in the future when you need to execute these documents again because it turned out you didn't do them right the first time.
Thank you. I will say that another resource is Dallas Area Agency on Aging.
Mm.
They will match you with an attorney who will wills, power of attorneys, all those things. That's what I used to create those documents for my mom. So that's another resource to check out is Dallas Area Agency on Aging. I'm actually gonna go back to the questions really quick just because
Okay.
some of them are related to what we're talking about. Right now. And so Tammy mentioned with Legal Shield, there's a reputable law firm with attorneys that are discounted due to the membership, and they have attorneys in each state per her research. So,
Okay. And yeah, so I would just make sure that you're speaking with an attorney that's licensed in Texas and they will say, I'm licensed. Make sure that they're licensed in the state in which you live because it will make a difference. If they are not licensed in the state in which you live, ask them if an attorney that is licensed in your state is going to review those documents before they get to you because I have seen wills, I've seen power of attorneys that just were wrong and they didn't have all the language that they needed. And they were drafted by someone who's licensed in Vermont or Oklahoma. And you wouldn't think that these little nuances make a difference, but they do.
okay. Since we kind of are getting on this conversation of out of state and whatnot, there's a question. Hello, my mother has dementia and my father has multiple sclerosis. They each have land through airship in Louisiana. Is land in another state counted towards the resource limit to qualify for Medicaid in Texas?
Hi, Shanna. First off, I'm sorry to hear about your parents' diagnoses. And you're definitely in my thoughts because that's a lot. I will say that um, I I believe that they can potentially be counted. I'm not entirely sure. I don't want to say for certain that they are going to be counted. I know that in the state of Texas, they will look at your assets and they typically want to capture all of your assets in the application, no matter where they are. And currently, for a single individual, it's right at $3,000. That's the max for assets. However, there's something called a qualified income trust that you can have set up. Another name for it is a Miller Trust, which will allow individuals to place assets in those trusts in the attempt to qualify for Medicaid. Those trusts are best drafted by estate planning attorneys and elder law attorneys, and you need someone that's licensed in that state. And I will say, even though that property is in Louisiana, someone that's licensed in Texas could draft a trust for you like that. However, in Texas, there's a 5-year look back period. So if your parents are going to need to qualify for Medicaid within the next 5 years, which may be possible, you're going to be at a difficult position because those assets, even if you place them in a trust, there's a possibility that you may not be able to shield those assets to fully qualify for Medicaid. Now, Medicare is something completely different. I will say that you have a lot of different options available for you. For the land in Louisiana, I would tell you to contact an attorney that's licensed there, and I can give you a name. I can drop one in the chat before the end of the webinar. And that individual may have some resources that are available to you to transfer those, the land and your parents' share of that land out of their name. Here in the state of Texas, there are two deeds that can be drafted. One in particular, if you want to Google it, is called a ladybird deed. And this is a really good deed that will allow your parents to transfer their assets or their property into the name of whomever. And because this deed has a springing interest and a future interest for someone else to own their land after their passing, the state considers this a gift to someone in the future. And so you're able to qualify for Medicaid with this deed for a particular property in Texas. I know that Louisiana doesn't have a ladybird deed, but you may have some other options available. But the short answer is, as far as I am aware, in the state of Texas, when you complete that application for Medicaid, they're going to want to know about all the assets that your parents own, no matter where they're located.
Thank you. And I'll actually go ahead and lead into that first question at the top, which is, can you explain the process of creating a trust to enable additional affordable resources?
Sure. So it really depends on the type of trust that you need, but in the caregiver realm, if we're talking about your loved ones to qualify for Medicaid, and so I want to back up a little bit and explain why we're talking about Medicaid. So when we think about dementia and we think about that cognitive decline, your loved one could have Alzheimer's disease or dementia, and there are so many different types of dementia, or your doctor may just say they have cognitive impairment, but medically, health wise, they don't have any other health issues. And so while their mind may be diminishing, physically, they're still in good shape. So, what happens if they live for another 30 years, 20 years, 15 years? What happens? You may find that because of their cognitive decline, you are unable to continue to care for them in your home or in their home as you would want. And so you're having to look at options for round the clock care with nurses or possibly at assisted living facility, a nursing home, what have you. If they're over the age of 65, they're going to be eligible likely for Medicare, and Medicare is only going to cover so much. The rising cost of healthcare here in the United States, we know, is trending upwards with inflation. Everything's going up, right? And there's often an additional expense that's there after Medicare pays whatever they're going to pay towards the care. So a lot of times families are left footing the bill. And you don't want to have to always come out of pocket and go into your savings or have to sell your parents' home just for them to afford this medical care as they continue to age and while they're declining cognitively, medically, they are still, doing well. So, one of the options would be to apply for Medicaid. And for those that aren't aware, Medicaid is an insurance, a supplemental insurance provided by your state government. And so every state has different requirements for Medicaid. These are going to be funds that would be provided after Medicare pays their final costs for whatever they're going to cover, whether it is hospitalization stays or doctor's visits or prescription drug coverage. Medicaid would then pick up the remaining balance. Now, here's the thing with Medicaid. If you can qualify for it, it's great, but what happens when that loved one passes away? Typically, when that loved one passes away, Medicaid usually does not attempt to recover the funds that they have paid out from the estate when it is an average estate where the person passes away. They have a typical American small home and they pass away and they don't have a lot of assets. However, my theory is that as we have the baby boomers and Gen X, as we continue to age, and more individuals need this long-term care because we're living longer, because while we have the rising cost of healthcare, we have improved healthcare and people are living longer lives. As more people tend to apply for and qualify and draw from Medicaid, I believe in the next 5 to 10 years, the government will start to recover or seek to recover all they've paid out to families in Medicaid benefits after someone passes away. So, what does that mean? If your loved one had a house and somehow they were able to qualify for Medicaid, and Medicaid through the course of their life paid out $150,000 for their care at their passing, when you go through the probate process, I believe that Medicaid, because it's called MERP and it's a um, Medicaid estate recovery process where they will attempt to list themselves as a debtor or a creditor on that person's estate so that the family would be responsible for paying Medicaid back everything that they've paid out or a portion of what they've paid out for that person's care. So, how do you get around that? A qualified income trust or a Miller trust. So, this is a special type of trust that's used primarily to help individuals qualify for Medicaid benefits while they still maintain their higher income level, um, typically higher than what Medicaid allows. As I said, it's around $3,000 for single individuals, and I think it's around $6,000 for married couples. So here's how it works. You have the income limit. Medicaid has income limits for eligibility and they vary state by state. If the person's income exceeds that limit, they will be ineligible for Medicaid benefits. But with this trust structure, it allows an individual to place all of their excess income over that $3,000 into the trust. This can help reduce their countable income, so it will help them meet Medicaid's requirements. It gives them access to funds for certain expenses, such as their medical bills, and then the remaining income after those expenses are distributed in accordance with the rules of your state. There are, like I said, state specific rules. Each state has their own regulations. And so this is why you have to go to an attorney that's licensed in your state for a qualified income trust. I'm going to be completely honest with you. This is highly specialized work. I would not get this work done by a legal Zoom or a legal shield. You want to go to someone who has experience in estate planning, preparing these types of trusts, or elder law, because elder law attorneys do these types of trusts. Um, when you establish this qualified income trust, these individuals will maintain their eligibility for Medicare, Medicaid, and also Medicare, and they're eligible for those long-term care services while still having access to some of their income for the necessary expenses. So I will say to you, if you think that you are someone who has those assets that are over the $3,000 limit, you want to talk with an attorney about getting a qualified income trust. And you need to do that sooner rather than later because that 5 year look back period is a very real thing where the government is going to look back at the 5 years prior to you applying for Medicaid, which is why I said that time is not a luxury that you have as a caregiver of someone with dementia. If you start trying to sell down assets, so giving away a car or getting these certain deeds or giving your loved ones $30,000 to try to sell down your assets, the government will become aware of that and you will be ineligible for Medicaid because they know that you're getting rid of those assets just so you can qualify, and they know that your loved ones are just holding them for you and then you'll eventually get them back. What's the loophole? How do you get around it? It's that qualified income trust.
Yep, that is so true. There was a question, is that the same as an irrevocable trust?
It's not the same. It's not the same. An irrevocable trust is a trust in which you put your assets into that they cannot be removed. This trust has a component of irrevocability, but it's not the exact same. So there are nuances. There are revocable trusts, there is a irrevocable trust, there is the Miller Trust, testamentary trust. There are so many different types of trusts, and they vary, the language varies on them. And that's why I said you want someone with experience to draft these for you, because if you don't have the language right, you're not going to be able to qualify.
Okay, and then one more question. When you say over the 3,000 income limit, is that monthly? Yes.
Yes.
Mhm. And there's a specific dollar amount. It might be
Yeah,
like
there's a specific. I'm using 3,000 as a
2,823. It's like there's a
yeah,
number. So you can
there's a
just
number.
Google it and look it up for
Yeah, and
yourself.
it changes yearly. I think they adjust it for inflation. And so it changes. But yes, you can Google it, and there is a monthly threshold,
Mhm.
maximum amount of assets that you can have in your name.
I have a couple questions about out of state.
Okay.
So,
Try my best to answer them.
it's more so just how do you find out more about the property transfer for other states? So Tammy specifically asked for Georgia.
Okay. I can drop some resources in your chat. I will say, Tammy, one of the easiest things to do is contact your state bar association. You can look on their website. Most states have a pretty flushed out website where you can identify free or reduced legal assistance. You can search for attorneys that are board certified. You can search for attorneys that have experience in elder law and estate planning. And you can contact, if you live in one of the major metropolitan areas like Atlanta, you can contact the Atlanta Bar Association. If you're a minority, you can contact the minority version of a bar association. Ask them when their legal clinics are. For instance, here in Dallas, we have a legal clinic. I'm a member of Friendship West Baptist Church. We have a legal clinic. It's the third Wednesday of we're doing it quarterly right now. It used to be every month. And we do that through the Dallas Volunteer Attorney Program. And so you're able to go to that program. And if you qualify, you meet certain income requirements, an attorney can draft these documents to you for free. But no matter what state you're in, I would start with your bar association, because they will be able to provide you with resources on identifying attorneys and possibly free or reduced legal services.
So we're going to send an email after the call, and we'll drop whatever resources that we have, including a PowerPoint with a lot of this information in it, that we'll send to everyone who was on the call. So just so you know that if agents on the POA live in different states, what's the best way to have each agent sign and notarize a POA?
So depending on the state in which you live, um, you may be able to do remote notarization, and it depends on which document it is. It's hard to answer that question because it may depend on the state that they live in and their state rules, whether they have to have this executed in that state. I have some clients that are all over the country. I have a client that's actually in Mexico right now, and I'm drafting a trust for them, and we're going to notarize it with a remote notary that's here in Texas. And so it just depends on your state and whether your state allows for remote notarization. If not, you will have to have the power of attorney drafted in the state in which the individual lives. So if the loved one that needs the power of attorney is in Texas, but the agent is in Louisiana, you may have to draft the document in Texas, email it to them or mail it to them, and they go and get it notarized there in their state. And once it's validly executed and notarized, then they become the power of attorney, and they can act no matter what state they're in.
Okay. And then Monica's question about an attorney in New York, as I mentioned, we will share any resources that we have, Texas and otherwise. Um, does the primary home count as a resource towards Medicaid eligibility, or is it exempt?
It is not exempt. A primary home absolutely counts, but depending on well, there are some deeds that are available to you that you can execute that can be like I was talking about, that springing interest that can get the home out of that person's name to qualify for Medicaid. And all of that depends on the timing of which you're going to apply for Medicaid. But one of those deeds is a special warranty deed with the reservation of enhanced life estate. I'm going to send out a PowerPoint that has the details for that. That deed is not a deed that's eligible in every state. There are only a handful of states that have that deed. Texas is one of them. Um, if you want to Google it, it's the layman's term, it's called a ladybird deed. Do not print it out online. Do not print it out online because there are some free ones out there that are floating around, but I've seen that they don't have all of the language in them that they need. And those little nuances can make a difference. Because if you don't properly transfer these assets, not only can it make it where you're ineligible for Medicaid, but it could make you have to go through the probate process after someone passes away. Because if you do this deed the correct way and you have done all of the things that I was talking about, like the homework of updating the paid on death beneficiaries. If you know that your loved one had dementia and you're a power of attorney and you've already transferred vehicles out of their name and you've gotten everything out of their name, even if you have a will, you may never need to probate that will because you've already gotten every asset out of their name and you've already executed this deed validly. That deed goes into effect at death. And so if you draft this deed, that springing interest of whoever those future owners are. So let's say your mom is going to leave her home to all three children in equal shares. That deed, even though you execute it and record it in your county, as soon as it's done, at your loved one's death, that deed immediately becomes valid. And now the home is in your name. And so you don't have to go through the probate process to get an executor's deed and all of these things. So, long story short, find a licensed attorney, even if you have to do it at a free or reduced cost, and get these documents validly executed.
Thank you. So we have a couple more questions here. We're almost about to hit our limit. So this is probably it that we're going to be able to do for question Q&A. But Tammy says, I know we went through this with my stepdad in Georgia. They were asking my mom to sign over his Social Security if he stayed in the nursing home over a certain number of days. It was a terrifying, horrible experience and time when my mom's emotions were already overwhelmed. Yes, I understand that personally because I've been through a similar situation in the hospital with my grandmother. So we hear you, Tammy, and we understand that. And Monica says, thank you. This is a rough time, but this session has taken me off the ledge. So we are happy to hear and that this has been helpful.
Yeah,
And,
so let me speak very quickly, if you don't mind, Veronica, to the Monicas. So, Monica, I will say to you, I understand that completely. And you have to recognize that as a caregiver, there are so many things that are out of our control. And so, in order to kind of take that anxiety down, you have to recognize what things you have control over. Know that even if your loved one is in that advanced stage, that you still have legal remedies available to you to take care of their needs. There's an option for you. And then all of the things that you can do, go ahead and start doing those things. And then the rest of it is above you now, right? You've done everything that you can do. I will say also, one of the things that I recommend for caregivers is absolutely to go through the estate planning process for yourself. I have seen individuals that call me and they say, hey, I got to get my parents squared away. And I actually had this happen. Someone was like, I got to get my parents squared away. And that person passed away before they got their parents' affairs squared away and they didn't have their affairs in order. So
wow.
I'll just speak personally and being very candid with you all. I feel like this is a safe space. For my own estate plan, I have a will and I have something called a testamentary trust. So at my passing, if I pass away before my mom, my assets will go into a trust for the care and benefit of my mother. So in the event that something happens to me, she's going to be taken care of. So this isn't just about you making sure that your loved ones' affairs are in order. You have to make sure that if something happens to you, your loved one that you're caring for can still receive that same level of care and hopefully qualify for whatever benefits they need to qualify for.
And then this last question says, can you review the process about owing the government after the person passes away?
So again, that's one of those things where it's a case by case basis, and it truly is. So in the state of Texas right now, when you pass away with or without a will, you're going to have to answer a question the attorney when they file for probate, whether you received Medicaid benefits on or after May 1st, 2005, because that's when the law was enacted for the Medicaid Recovery Act. This came about because Medicaid was paying out millions of dollars to people who were passing away with rather large estates. And when I say rather large estates, maybe the person was on Medicaid, but then they want to scratch off and they passed away with $300,000. And so Medicaid's like, okay, well, we've paid out $40,000 in care for this person over the last year. We're going to need our money back, right? And so it really is a case by case basis. I've seen some of my probate cases where the person passed away and they have a house somewhere here in Dallas and the house is worth $200,000. They had some credit card debt. They had non-probate assets of life insurance, and those don't count. We're talking about probate assets. So that's why it's super important to have those beneficiaries listed. And that person received Medicaid. Medicaid, you have to go through the process where you notify Medicaid of that person's passing. You identify assets that are a part of the estate. Medicaid will review and they will let you know whether they plan on attempting to recover from that estate. Once you get the sign off that they are not attempting to recover, then you can proceed with the probate process. If they are going to recover, sometimes you have to set up a payment plan. You may have to sell your home. And again, these are case by case. And the law is different for all 50 states, and it's on a case by case basis. My comment was to the rising cost of healthcare. And because there are so many baby boomers that are now living longer and will need long-term care, that Medicaid is going to be exhausted. States are going to be paying out more and more for people's long-term care. And I suspect that they're going to start attempting to recover from families as time goes by.
Whew, that is so unfortunate. I have like one more question here. And as I mentioned, everyone, we will be sending a PowerPoint with a lot of this information in it and answers to some of the questions and resources that might be helpful. The last question that I have is, are there any resources, websites, books you would recommend that caregivers look into to get started or to improve their estate planning?
Yes, so I will say here's one that I recommend, not necessarily to improve your estate planning, but just if you are a caregiver and you're feeling overwhelmed and it's just hit you with a ton of bricks. There's a book called The 36-Hour Day by, let me see, I have it written down. It's on my Kindle, and I probably could share it with somebody at some point. So it's The 36-Hour Day by Nancy L. Mace, Mace, and Peter V. Rabins, Rabins. If you type in The 36-Hour Day, and it's specifically for those that are caring for someone with dementia or some type of cognitive impairment, and it is written in concert with individuals who recognized that they were having diminished capacity and they assisted in writing. So there's some personal stories in there about individuals who noticed that their memory was fading and they started doing certain things like contacting an attorney or sharing their desires with their loved ones about their end of life care and what have you. And so it's a good book just to kind of calm your fears. And then the other resources, which we'll send in an email, are oh, let's see. I got quite a few of them. It's a bunch of them. And I will say, we'll send them in an email. There's like the National Elder Law Association, the American Alzheimer's Association, the American Bar Association. So we'll include those in a follow-up email to you. I will be sending this information over to Veronica within the hour, and we'll get that email out to you with some resources and practical tips to kind of calm your fears a little bit.
All right. Well, that brings us right on time to go ahead and close out. I want to remind you, if you're not on the Dementia Care Warriors email list, make sure you go to our website, dementiacarewarriors.org, join the email list so you can stay in the loop about these types of events. As I mentioned, this is part one of a series of webinars for this month. Next week, we'll be talking about emergency preparedness for caregivers with all of the things that are going on in the world. I think it's important for us to be prepared for whatever is to come. And then finally, we'll talk about grief with a death doula. And so death doula is a thing, something fairly new that a lot of people are not familiar with. So I want us to become familiar with all of the resources and options that are available to us as caregivers. So again, thank you for joining us, and we hope to see you next Tuesday. Thank you to Alexier. Did you have any closing words or?
I will just say, make sure you guys do that homework. We're going to send out the PowerPoint, and it's a PowerPoint. It's my actual estate planning presentation. So it'll identify some key documents that I recommend, and it will give you some takeaway things to do. But just recognize as a caregiver that you are doing work that many aren't going to do. You've been called to this work, and that you have everything that you need within you to get this job done. The work is hard, but it is rewarding. And just know that it's going to work out. There are resources that are available no matter what level of care your loved one needs or where they are in their capacity. There are legal remedies that are available to ensure that their health and their finances can be protected.
Thank you so much. And thank you, everyone. We'll see you next Tuesday.